Hi everyone, in this video I want to share my opinion on 3 things that you need to know in order to pass the NCAA criminal law exam. The first thing I want to talk about is why do you need the criminal code and what type of criminal code do I recommend. The second thing I want to talk about is the thought process behind establishing an offense on the NCAA exam. So I'm gonna pull up like a random section from the criminal code and I'm gonna show you the thought process behind establishing an offense. The last thing I want to focus on is the difference between subjective mens rea and objective mens rea. I think that it can get a little bit tricky. So I thought that maybe I can share my understanding and this might be helpful to you. So if you're interested, keep watching. Before I go on to the 3 things that I mentioned, I want you to understand that the NCAA criminal law exam is testing you on your concept. So are you able to understand a test and are you able to apply that test to the facts? So when you're reading the material, make sure that you understand how law is applied to the facts, how case law is used in order to prove different types of conclusions. So this is something that I did back in the day. When I was reading cases, I kind of selected some cases that I thought had a very good analysis. And what I did is I would use that case as a framework on the exam. So the way that the analysis was written, I would use the same structure to answer the exam question on the exam. So if you think that this might be helpful to you, maybe you can use it too. It really depends on what type of case you think is best for you. But I don't remember the case that I selected back in the day. But this was certainly really helpful because on the exam, when I had to write an answer, I just had a framework and I followed that framework that I had selected. And one of the other things with NCAA criminal law exam is that I would highly recommend that you take this course really seriously because you're going to be tested on criminal law again when you're writing the Ontario bar exams. So that is the barrister exam. So if you can study a lot right now and you're able to understand all the major concepts, you're going to have, it's going to be a lot easier for you to write the barrister exam. And this is one of the mistakes that I made, was that when I was studying for the NCAA exams, I obviously studied to pass the course, but I did not go into too much detail, which now that I think about it, I would highly recommend that you do it because you're saving time. Once you're running the barrister exam, you can definitely use this knowledge because it's very similar. First thing that I want to talk about is why do you need the criminal code? First of all, you need to understand what is the criminal code. The criminal code is the law that contains most of the criminal offenses in Canada. Now, when you open the criminal code, you have different sections, and those sections contains the law, like what is the offense, like how are you going to establish this offense. So why do you need it on the exam? Now, if you take a look at the syllabus tells you that you should be able to look at the criminal code, and if you're given an offense, you should be able to first of all find that offense on the criminal code, and then you should be able to interpret that provision and then apply it to the facts. So you need the criminal code because let's just say that you get a section, you need to look that section up on the criminal code and then read it, and then you have to apply that law to the facts. Now, all the sections mentioned in the criminal code are not obviously discussed in the syllabus. So it's important that you have the criminal code because if you don't, then you're most likely going to fail. So please make sure that you have one. Now, I'm going to share the one that I use right here. This was an annotated criminal code, and I think it was perfect. And I think that I used it on the exam as well, and I found it to be really helpful. And I purchased this from Emon, so if anybody wants to purchase it, you can purchase it. I'll put the link down below. Now, what type of criminal code do I recommend? Now, if I were you, I would trust what the NCAA is saying. The NCAA highly recommends that you get an annotated, most up-to-date criminal code. And I wouldn't trust anyone else. I would highly trust what the NCA is saying, because they're the one who will mark your exams, and they know what they're saying. So when in doubt, always go back, read the syllabus, and read anything that's on the NCA website. So again, my recommendation would be to follow what the NCA is telling you. So buy the criminal code that is annotated. Next thing that I want to talk about is how do you establish a criminal offense on the exam. What I'm going to do now is I'm going to share my screen, and I will pull up a random section from the criminal code. It's just a random section. It was easy, so I thought that maybe I could use that. I don't know what's going to come on your exam, so it's just totally a random section that I'm going to pull up. And I will share my thought process on how I interpret that section, and how what type of issues I look for whenever I'm interpreting a section. So yeah, I'm going to share my screen now. I have the criminal code, and I've picked up this provision, which is section 398. And on the right side, I have some points that I'm going to walk you through. Now, this is a criminal offense, and I'm not talking about regulatory offenses. There's a difference between a criminal offense and a regulatory offense, and you can look at the difference on the syllabus. So the first thing that you want to do whenever you are interpreting a section is you want to make sure that you understand what is the actus reus, which is the act, and then the mens rea, which is the mental element. So in this case, when you're trying to find the actus reus, you just have to ask yourself this question, that what is the person supposed to do in order to be liable for this offense? So in this case, the person needs to falsify an employment record by any means. So this is what the actus reus is. So I've just put the actus reus down here. The next thing that you want to know is what is the mens rea of this offense. So mens rea is the mental element. As you can see, the mens rea here is with intent to deceive. So on the right hand side, I have put that the mens rea is with the intention to deceive. Now, once you know what the actus reus is and the mens rea is, you're obviously going to get facts on the exam. You will have to apply the facts to this section and see if that person actually did falsify an employment record with the intention to deceive. So obviously, I don't have facts here, but this is how you're supposed to think when you get a section that you need to interpret. Now, let's go to the right side of my screen. I always like to start with telling the examiner that I know that in Canadian law, we're supposed to interpret the section using liberal interpretation. And what does liberal interpretation means? That you understand the purpose of the provision, and you have to make sure that what is the provision asking you to do. And this is the wording that I got from your syllabus. So let me just show you where I got it from. Yeah, so it is number 4 and 4C, where they talk about in Canadian law, this is the type of interpretation that we should be focusing on. So I like to start by telling the examiner that, hey, I know that Canadian law makes liberal use of purposive interpretation, and this is what I'm going to be doing as well. Now, let's go back to the section. Then we want to tell the examiner that we know that the actus reus is falsifying an employment record, and then the mens rea over here is with the intention to deceive. Now, I'm not going to be discussing causation here, which is also an element, because where an offense requires a specific consequence, so for instance, criminal negligence causing death, this is where you need to discuss causation. So in this section, I don't see anything which is requiring a consequence. So I won't be discussing this here. Again, on the exam, I don't think you're going to get a very simple section like this. So maybe you will have to discuss causation. So make sure that you do understand factual causation and legal causation. Now, once you've figured out actus reus and mens rea, you will obviously have to apply this to the facts and see what type of cases you're going to use for your analysis. So just an example, for instance, over here, the mens rea is with intent to deceive. Now, this is what I like to do. I like to go back to the syllabus or my notes, whatever I have. I always like to go back to the syllabus because I know what the examiner is expecting from me. This is why I like to always look back and see if I missed something. So on the syllabus, I'm going to go to mens rea. So this is where it talks about subjective mens rea. Let's go to the bottom and let's see what the examiner is talking about. The examiner is talking about the most common mental states. And over here, they mention intention. And at the bottom, the examiner also mentions these two cases that, you know, you need to look at when you're talking about intention. So if I were you, I would make use of these two cases. Obviously, you have to see if the facts are relevant. Even if the facts are not relevant, you could still try to see if you can fit these cases in. I would. And when you're discussing intention to deceive, I would highly recommend that, you know, you do use these cases. And this is exactly what I did on the exam. Whenever, if I had a mens rea element or actus reus element that was on the syllabus and it was talking about the cases that you have to use, I would use all the cases mentioned below. So yeah, so that's how you will do that. Again, you will have facts on the exam and you will have to apply the facts to the law, which is, again, we're discussing the law here. Now, whenever you get an exam question, you should always ask yourself, did anyone help cause the crime? So this should be help in causing the crime. So what that pretty much means is that, do you have anyone else with any other person who was helping cause this crime? So again, if you take a look at the syllabus talks about, you know, there are certain ways where people can help other people in committing a crime. So, oops. Okay, this needs to stop. Yeah. So for instance, aiding and abetting, counseling, attempts. So these are some of the issues that you should be mindful of when you're obviously discussing, when you're writing the exam answer. And then the last thing you want to know is what type of defenses can you discuss here. So the most important thing about defenses is that you want to make sure that you understand whatever defense that you're discussing. What is that defense doing? Is that defense negating the actus reus, or is that defense negating the mens rea? So you want to know what that defense is doing, because this is what will tell the examiner that you know what the defense is doing and your concepts are clear. So again, these are different types of defenses that you could discuss. Again, it will depend on the facts that you get. Like for instance, when you talk about involuntary acts, this type of defense is used to negate the actus reus because, you know, whatever the act was, that was involuntary. So again, you want to know what the defense is doing. And the last thing is that whenever you are interpreting the criminal code, you also want to know what is the punishment. So over here, as we were talking about section 398, if somebody is liable under this section, he or she is guilty of an offense punishable on summary conviction. So this is just my thought process. Again, there might be some other issues that you want to discuss too, but this is just a basic understanding of some of the things that you want to be mindful of. Last thing I want to talk about is the difference between subjective mens rea and objective mens rea. I think that these are tricky concepts because once you start reading the case law, it gets a lot more complicated. So I thought that maybe I could share like the basic understanding of what is subjective mens rea and what is objective mens rea, so that once you read in the case law, you have a basic understanding of these principles. So subjective mens rea pretty much means that what was my state of mind at the time that I did something. So what was I thinking at the time? I'm going to give you an example to make it a bit more interesting. So for instance, I have a friend who I don't like, and the reason that I don't like her is because she always gets good grades, and, you know, I'm kind of jealous and I don't like her. And one day we decide that we're going to go get ice cream. And when we go get ice cream, and when we're both eating ice cream, I decide to shove my ice cream up her nose, and because of that she's not able to breathe, and then she falls on the floor. Now when we're talking about subjective mens rea, what we're really looking at is what was I thinking at that time. Now you know that I was thinking that I don't like my friend because I told you, but it's not easy in criminal law to guess what the other person is thinking at the moment. So when you're talking about subjective mens rea, at the end of the day, it is construed by using common sense. like, for instance, if you see me shoving my ice cream up somebody's nose so they can't breathe, you're likely to think that I was thinking of actually shoving it up her nose because I don't like her. So what I'm really trying to get to is that subjective mens rea means what was my state of mind at the time. And because you can't really guess people's state of mind, you're gonna have to use your common sense to figure it out. Now, when we're talking about objective mens rea is very different than subjective mens rea, because objective means according to a reasonable person, whatever I did, reasonable or not. Like, what would a reasonable person have done in my scenario? Would that person shove an ice cream up somebody's nose? So that is the difference between objective and subjective. Again, subjective is what was I thinking at the time that I did something. And again, because you can't guess what somebody was thinking, so you kind of just use common sense and construe it with all the circumstances that are present at the moment. And objective is when, what would a reasonable person have done in this particular scenario? So I just thought of sharing this because this was a little bit tricky for me. And now that you know what the basic understanding is, it's going to get more complicated once you start doing the case law, because again, it's criminal law. It is complicated. I hope that this video was helpful to you. And if you liked this video, then you should give me a thumbs up and you should subscribe to my channel, because I'm going to talk about the other NCA courses that I took, and I'm going to make the same videos so that just to give you guys an idea of what I think is important when you're studying for these exams. So I'm going to talk about admin law, constitution, property, contract, and business organization. So if you don't want to miss my videos, please subscribe to my channel. And I hope that this was helpful. I wish you good luck. I know that everyone's writing exams online, and trust me, I'm getting nervous thinking about it because I'm the kind of person who likes to write and not type. So whoever is writing the exams this year, so yeah, in August, I think that it's great, and I hope you good luck, and I hope that this was helpful.